Okay, I asked the internet this question. I know the answer, but the internet is not quite giving you what I would give you. They're giving it to you indirectly, and I give it to you directly. Lawyers are bound by strict ethical codes, and those are the rules of professional conduct. And they fail to abide by the rules of professional conduct. Those are ethical violations as well. These obligations require them to act competently, maintain strict competence is a rule in the rule of professional conduct. Okay, so they're mentioning the rules of professional conduct without mentioning the rules of professional conduct. Maintain strict client confidentiality, that's in the rules of professional conduct. Avoid conflicts of interest in the rules. And vigorously advocate for their clients' interests while remaining honest and upholding the integrity of the legal system, which is a quote from the rules of professional conduct. Duty to the client competence, provide a representation using necessary legal knowledge, skill, and preparation. Confidentiality, that's in the rules of professional conduct. Competence is a rule. Failure to be competent is breaking the law, okay? Confidentiality, that's breaking the law. Protect all information relating to the client's representation from disclosure which goes beyond the standard attorney-client privilege. Loyalty and conflicts of interest, avoid representing clients with adverse interests in situations where personal interests might interfere with professional judgment. Communication, that's the law. Keep clients reasonably informed about the status of their case, promptly respond to requests for information. That's in the rules of professional conduct. Like I told you before, it's impossible just to violate one rule when violating the rules of professional conduct. That's ineffective assistance to counsel. Duty to the court and legal system. Candor and honesty. Candor towards the tribunal is a rule in the rules of professional conduct. Candor and honesty, lawyers are forbidden from making false statements of fact or law to a tribunal and must correct a false evidence. Frivolous claims, refuse to file meritless lawsuits or engage in stalling tactics. That's what I'm going through right now. Frivolous claims, lawyers trying to evict me because I refuse to pay the rent increase, but I refuse to pay the rent increase because they refuse to make the mandatory repairs. So it went from evicting me to suing me for past rent, but the past rent that they want to collect is the increase, but they're not making any of these mandatory repairs. Okay, frivolous claims, refuse to file meritless lawsuits or engage in stalling tactics. Stalling tactics, that's basically procrastination, is forbidden in any court of law. Diligence is required, which is a rule. Expediting litigation is required, which is a rule. Failure to do that is breaking the law, either or. Frivolous claims, refuse meritless lawsuits, or engage in fairness. Treat opposing counsel and parties with fairness and respect. That means abiding by the rule of professional conduct as well as enforcing them. Financial and trust obligations, safekeeping property, which is a rule in the rules of professional conduct. Clients' funds such as settlement payouts or retainers must be kept in dedicated trust accounts separate from lawyers' own operational funds. Congregating funds is strictly prohibited. Okay, but they'll do it anyways. Professional regulation, self-regulation. Attorneys are expected to maintain the high standards of professionalism and report ethical violations committed by other lawyers or judges. Lawyers and judges are legally required to report any misconduct by lawyers and judges. It's mandatory in both the rules of professional conduct and the code of judicial conduct to report any misconduct, any violations of the rules of professional conduct, the code of judicial conduct. Just having any knowledge, they do not have to be participating in a case. Having general knowledge of the failure to abide by the rules or the codes, misconduct, is mandatory to report. Fail to report that misconduct is misconduct. Okay, remember, this is deprivation of rights here, right, people? The responsibilities are guided by the American Bar Association. Oh, it tells you right here. The responsibilities are guided by the American Bar Association rules of professional conduct, which most U.S. states adapt into their own binding codes of conduct. In the Illinois specifically, The profession is regulated in the Illinois Supreme Court through the Attorney Registration and Disciplinary Commission. Okay, so this is what gives you effective assistance of counsel. Before you even find a lawyer, you have to go to the ARDC itself, lawyer registration rules. Okay, so I'm going to click on Illinois Rules of Professional Conduct. Okay, this is what gives you effective assistance counsel. You go to the preamble scope. I'm going to go over this with you later, but none of that's happening, okay? You can go through all this. This is all ammunition you can use against them. I keep telling people, go over. This is supposed to happen at the very beginning. And because it didn't, anything thereafter is nothing but frivolous litigation. Meant nothing but to harass you, to get you to give up hope. See, look at competence. That's a rule. These are all laws, okay? It tells you that in the preamble. Scope of representation, allocation, authority between client and lawyer, and that's what it was talking about, conflicts of interest. It'll get into that later, but look at competence. Just open that. A lawyer shall provide competent representation to a client. Competent representation requires a legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. And then you can go over here into the comments and use that language to describe what they didn't do when it came to competence. Okay, diligence. Okay, so on the internet it tells you quick and speedy trial is only guaranteed in a criminal trial, but if you refer to the rules of professional conduct, it says what? Diligence. The lawyer shall act with reasonable diligence and promptness in preparing or representing a client. Okay, so you can go to the comments to have more on that. Okay, communication. There's always a lack of communication. Okay, lawyers shall promptly inform the client of any decision or circumstances with respect to which the client informed consent. Okay, so I talked to you about informed consent. So you're going to want to have, a lot of this doesn't happen. Okay, fees. So, no fee is reasonable considering the fact that nobody's doing this. Confidentiality of information. Every time I spoke with people to help them, especially in criminal court, when asking for a probable cause hearing, the public defender saying the judge isn't going to like that, goes and tells the judge and the state's attorney, and next thing you know it's going to trial. There's no confidentiality. That's ex parte. Conflicts of interest, which it mentioned that earlier. Okay. Duties to former clients. Even though the lawyer is not legally representing any lawyer who has formerly represented a client in a matter, shall not thereafter represent another person in the same or substantially related matter. Okay, special conflicts of interest. Client with a diminished capacity. You can use that for yourself. If your lawyer was dealing with his client with diminished capacity because you lacked the reasonable knowledge to make an informed decision to give informed consent. Informed consent is required before anything can go before a trial. And that informed consent would be to divulge discovery. A lot of views I know I went through where our discovery was withheld, and it's mandatory in disclosure. Look up disclosure law. It's mandatory, to reveal this discovery in fairness to the opposing party and counsel. Declining or terminating representation. I've had lawyers quit on me for bringing up the rule of professional conduct. Drop of a hat, which is illegal. But I filed with the ARDC and they won't do anything. File with the Judicial Inquiry Board, they won't do anything. But I'm going to keep trying. Advisor, okay. In representing a client, a lawyer shall exercise independent professional judgment to render candid advice. In referring to advice, a lawyer may refer not only to but the considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. Okay, but remember, they're supposed to advise you about not breaking the law, or if you. Okay, so when you make this, you're going to want to claim you have meritorious claims and contentions, when it comes to them violating your right to due process, a fair trial, effective assistance to counsel. Okay, lawyers shall not bring or defend a proceeding or assist controversy in an issue unless there a basis of law fact in doing so that is not frivolous. Okay, so meritorious claims and contentions means, no frivolous claims, people, but they'll do it anyway. Expediting litigation. Again, I said, like, quick and speedy trial. It doesn't outright say it, but if you refer to the rules of professional conduct, a lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. And the interest of the client is a quick and speedy trial. That would be diligent. That would be competent. Did anybody communicate that to you? Okay, so you notice I just threw a bunch of laws at you. Fairness to the opposing party. Often lawyers have said to their clients that, the opposing party lacked diligence in expediting litigation. And when I pulled out the rules of professional conduct and started quoting them, suddenly things started moving along. Impartiality and decorum toward the tribunal. A lawyer shall not seek influence a judge, juror, but it always starts with the judge. Okay, communications ex parte. Okay, so you're going to want to get into that. Impartiality and decorum, because that doesn't happen. Trial publicity. I was watching and some lawyers were putting some trial publicity out there, and the state's attorneys were getting death threats and their families, and so no, that's illegal. Okay, so I'm not a bootlicker, but still, it's the law. Okay, lawyers as a witness, special responsibilities of prosecutor. I went over that, and that doesn't happen. The duty of a public prosecutor to seek justice, not merely to convict. The prosecutor is in a criminal case shall refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. That's why I always tell the defendants, insisting on a probable cause here. But anyways, none of this happens, and it'll tell you in here if the prosecutor becomes aware of exculpatory evidence in a case in their jurisdiction, or even in any jurisdiction, it's their job and duty to exonerate that case. It's down here in G, F, and G. Okay, so you want to read that, and also go through the comments. It tells you about a U.S. attorney is a representative, not of ordinary duty to controversy, but sovereign, whose obligation, given impartiality, is compelling as it is to obligation govern at all. Okay, but you're going to want to get into that. Okay, so special responsibility of prosecutor. You can get any prosecutor on that, because they don't do that. That's deprivation of rights. Okay, that's a federal crime. It's just that nobody's talking about it because everybody's doing it. Truthful statements to others. Okay, so come on, this doesn't happen, especially with lawyers. Make false statement of material fact of the law to a third person. Okay, I've had lawyers tell their clients, no, the rules of professional conduct only apply in criminal cases, which is false. Only Rule 3.8, Special Rules of Prosecutor, applies in criminal cases. All the rules apply in every court of law except for Rule 3.8, which is a special rule for criminal cases. Okay? Dealing with unrepresented persons. I got arrested, and they decided to bring in the state's attorney, and the state's attorney is going to offer me, a plea deal, and she knows she wasn't supposed to be in there, and I questioned her about that, and she took off, and they weren't going to give me a lawyer, but they did, and then they threw the case out. Responsibilities of a subordinate lawyer, responsibilities regarding non-lawyer assistance. So anybody that's assisting your lawyer can be held just as responsible for the person they're working for, according to deprivation of rights or conspiracy against rights under the color of law. And just taking orders is not a viable defense. Ignorance of the law is not a viable defense. You can look it up. It's on the net. Okay. Advertising. See, reporting professional misconduct. It used to say reporting professional misconduct is mandatory. But when you open it up and read it, it'll tell you any lawyer that doesn't do all this, a lawyer who knows that another lawyer has committed violation of the rules, shall inform the appropriate professional authority. A lawyer that knows a judge who has committed a violation, applicable rules of judicial conduct, so they got to report them to, proper authorities as well. Misconduct. It is professional misconduct for a lawyer to violate or attempt to violate the rule of professional conduct, knowingly assist or induce another to do so, or to do so through acts of another. Okay, so not abiding by any of the rules is misconduct. It's mandatory to report misconduct. Nobody's doing that. Okay, so this is all to aid and assist. And on the internet, it'll tell you it's not legally mandatory for lawyers to report misconduct, but reporting misconduct is mandatory. Failure to report misconduct is misconduct. So your lawyer is legally required to report the opposing party and judge for misconduct for their failure to report your lawyer for misconduct. Okay, people. I hope I made that short enough for you. Okay, okay, so I told you, what are the requirements of effective assistance of counsel? And I just went over that with you. All right, people, you have a good night. All you got to do is look up the Rules of Professional Conduct, the Code of Judicial Conduct. Take that with you to a court of law and make sure everybody does that word for word, to letter, as required by the letter of the law. Penalties for violating the law are fines, removal from public service, and incarceration. Remember, they took the oath to do that. Look up the oath of public service. Okay, the oath to the Constitution always comes first. Okay, failure to abide by that oath is deprivation of rights, which is a federal law, and them not being charged for violating the oath, deprivation of rights, proves a conspiracy against rights under the color of law. Okay, thank you and good night. May your Creator always be with you and rain many blessings. I wish you a long life and good health. Nothing but peace and love. All right, hey, I have somebody coming over. It was the last person I went and helped in criminal court. After that, my body gave out. I couldn't do it anymore. I'm handicapped. And I'm going to talk to him, go over the rules of professional conduct with him. And, the laws behind the quick and speedy trial, and a whole lot of stuff. I'm going to do as quick as possible like I did here. He said he'll be over here later. All right, thank you. Nothing but peace and love. Good night.